everybody, and welcome back to the 50-Day Property Challenge brought to you by the EDPF Property Academy and Private Property. Today, with Jared and Matt Al, we have in the room the very famous Mr. Meyer, my favorite attorney in Cape Town. He's been involved with the EDPF program for close on 5 years now, where he is teaching our entrepreneurs in the program everything they need to know about the legal aspects of property. So if you want to get hold of him, Meyer is here in Cape Town, and if you need to contact him, his contact details are on our website, edpfpropertyacademy.com. You can just go to the support link and you'll find him there. So if you want to contact him after the session and you need anything done from a transfer perspective, then that's where you will find him. Today, we've asked Meyer to talk to us about the transfer process. As you know, Jared has now bought his first property and Matt Al is about to buy her third property. And while they wait for the transfer to happen into their names, we just thought maybe it would be good for us to talk about how that transfer process happens. Because as buyers and sellers, after all the paperwork is done, we sit back and we wait and we're not sure what's going on in the background. So we thought maybe today we would talk to Meyer and ask him, from the day we sign the offer to purchase, what all the processes are until the day we actually take transfer. So I'm going to be quiet now and I'm going to let Meyer talk. And if there's anything that I think we need to maybe clarify, I'll then interrupt him and ask him to clarify that particular issue or topic. So Meyer, all over to you. Our audience know you. We've already had some conversations together, so no need to really introduce yourself this time. But Meyer, just tell us all about the transfer process.
Thanks a lot, Nigel. Really appreciate it. I'm Meyer, attorney of MDW Incorporated, and I've been busy with transfer of properties for the last 35 years. So I can say I've done a couple of them. So the transfer of a property is quite a complex process, particularly for the person looking out from the outside, because you deal with so many stakeholders. First, you start looking around for a property if you are a buyer, and you search around the internet. Maybe you get a hot tip from Nigel, and then you go and buy that property. And you obviously have learned through the EDPF program as well to do your due diligence, because we always say when you buy a property, don't always buy it with a heart. You always buy it with a calculator. Particularly if you buy investment property. We've learned that we are now engaging on the third property as well. If you're a first-time buyer, you can also make use of a government subsidies called FLISP, F-L-I-S-P. So the whole idea of why I came to this program, and I said I would like to share my knowledge because people don't know. And there's always the saying, if you don't know what you don't know, then you don't know what you don't know. So looking at the conveyancing and the transfer process, you've now searched around on the internet. When you have actually gone and visited a few properties, you've done your calculations, you've gone to the big thing and you signed this offer to purchase. People call it OTP. Now I'm dealing in a lot in the tech world as well. And then they say to me, well, you must just check your OTP. And then I think, okay, that's my offer to purchase. And they say, no, that's your one-time password. So people can sometimes get confused with all the technology. You can also refer that as an OTP to a deed of sale or a sale agreement, but that's your legal agreement. And remember that once you signed an offer to purchase, which is the long for an OTP, that offer is a legal document. And the moment that you sign that document, people say to me, no, I've just made an offer to the seller and I can pull it out of it any time. But unfortunately, by the time that you have accepted that OTP or the seller has accepted that, it's a legal and binding document. So now the question happens, what happens from here? Because you've done the big thing, you sign on the dotted line, and now the next thing is to say, what now? Now one of the parties in this discussion today, we bought the property for cash. Now that's quite an easy thing because you've got to have the money available. I'm busy with 2 transactions now where the buyer puts down the deed of sale. The deposit is payable on date of signature. At the moment we start calling for that deposit, they say, oh, sorry, but the money's come from overseas. I'm going to need about a week to release the money. So very importantly, in your offer to purchase or your deed of sale, make sure that the information that you put in matches your budget and your cash flow, because you can't make an offer to say, I'm going to pay this deposit within 24 hours, but the money still lies in an investment account that you need to get the money out. Those are just small tips from my side. So the first thing that you're going to be required on is that the offer, if you require property finance, it will go out most likely to your bank or to a mortgage consultant. We always advise go to a mortgage consultant. And what we also offer from our side is that we've got the services to help you with a bond application. Nigel, you've got that service as well through the EDPF. And your bond consultant will go out and search for you for the best deal. Remember that not your own bank often doesn't give you the best deal. You feel like, hang on, I've been banking with this bank for 20 years. They need to extend the loyalty back to me. But quite often that bank doesn't have the appetite at that time of the month or the term to actually look for new clients. They maybe have pulled a little bit back on the acquisition of new home loans. And when you find an opposition bank actually gives you a better opportunity and a better solution. If you need a FLISP subsidy, you can actually get a pre-qualification on your subsidy, and then you can actually apply for a smaller home loan. That means that you can negotiate better with a bank because you have a deposit available. So there are so many things that you need to know. And if you have a skilled bond originator and a team with you, and again, Nigel, you've been punting all the time, when you buy a property, surround yourself with experts. Don't go out there and kind of think, I can do it on my own. I bought, for a few years ago, I was driving my own car, old car, for 10 and a half years. So when I went out to buy a car, I was completely bewildered in the whole process of buying a car. So the same applies for a house. You maybe buy one or two or three or five houses in your lifetime. When you're over three, you maybe feel that you're an expert now. But on your first or second house, get experts, get a team around you. And this is what Nigel and the EDPF helps you with, and surround you with a team. So the next thing is you now look for the best home loan. Once you get your home loan, you most likely will get 2 or 3 comparative quotes. The one may give you a 100% bond. You think, great, this is what I'm going to go for. The other one asks you for a 10% deposit. But now you start looking and comparing your interest rates, because your interest rates may vary. A 100% bond will have a high interest rate. I've done a calculation that 2% over prime will cost you 52% more for that property, paying back over 20 years. Now you think, 2% is not too bad. I don't want to put down a deposit because I rather want to gear my property to the maximum. But that 2% costs you very expensive in the long run. So now you've got your home loan approved. And what we find also, there's a disconnection between what happens now. If you apply for a home loan, quite often that estate agent just gives the deal over to the bond originator, and they kind of disappear, and they just wait until 14 days have passed, and then they say, what happened to the bond? And if the bond was approved, then they say, great, because the seller will then nominate a conveyancing attorney, and the seller has the choice to nominate the conveyancing attorney, and it's not the purchaser, although the purchaser pays for the legal fees. So now the agent will ask the seller, who's your conveyancing attorney? And before the bond is approved, we prefer to receive that instruction to tend to the transfer. Why? Is we can open the file, we can ask the parties for the FICA documents, we can ask them for the IDs, we can ask them for everything that we need to open the file. And we can start loading the documents on the system. If a seller does have a bond over the property, we will then also write a letter to the bank to say to the bank, the seller has got the intention of selling the property, and can you please put up your bond for early termination? Now this is very critical. We actually like clients to come to us very early, because if we issue that letter in advance, it means that your 90-day penalty fee starts to trigger and run much earlier. Otherwise, the bank will give you a cancellation figure to say that you owe him 800 or whatever amount on the date of transfer, plus 3 extra months of penalties because you didn't give him notice early. So my word of advice to EDPF members is give that advice to your conveyancing attorney early if you sell the property, because then your 3-month penalty starts to run. So now we are already on the third party. We've dealt with the estate agent. The agent handed it over to the bond originator or the bank, and now you are with a conveyancing attorney. The conveyancing attorney is a qualified person that's got the skill and also the education through the LPC, that's the Legal Practice Council, the old law society, and that person has passed in a particular exam and has got the skill and the knowledge how to deal with a transaction from there. Now, I had people that say, when I was attending some seminars, they say, you know what, conveyancing is a little bit like a boring job. I say, no, it is most exciting because you are dealing there with expectations. The seller has sold the property, the buyer has bought the property, and you're in between there, and you've got to help to manage the expectations of everybody. Now, as a conveyancing attorney, you go through the deed of sale. You often make sure you check that there are no mistakes that are often made in the sale agreement. Quite often there are open paragraphs like, I'm taking occupation on a particular date. The date is not in there. The bond needs to be approved on a certain date. You always go through the sale agreement and check, number one, that the agreement is completely a legal document. Then the next one, we look at when is the deposit payable, when are the guarantees and the balance of the purchase price payable, and are there any extra conditions? For example, just now before the session started, I was dealing with a seller that built on extra onto a sectional title apartment, but that person didn't have a legal documents from the body corporate. Now it's a big fight because the seller and the buyer and all that stuff. So again, get your house in order before you sell the property. But again, the legal team brings everything for you together. Quite often, everybody just runs away and say, please, you're now attending to the transfer, sort this mess out as well. So the third parties are now the conveyancing attorneys. First the agents, then the bond originators, and also the bank come in between, because if you work with a bond originator, they will give you a quote from 3 different competing banks. You will then select the first best one, you'll accept those conditions, and go through those conditions very carefully. As I said, they can catch you out with a too high interest rate. They can ask you for guarantees or sureties by a parent or a spouse or something like that. So always go and look at the conditions that are in that, because the moment that you accept that, you have signed a legal and binding document number 2, and that is with the bank. So the bank now triggers their administration once your bond acceptance has been done, and they will issue instructions to a fourth attorney or fourth party here, and this is the bond registration attorney. So now we've got another attorney here, and the buyer really looks around and say, I've dealt with the agent, now the bond originator, now the attorney, this attorney. How does it all fit in? So the transferring attorney is the attorney that's in charge of the entire transaction. He or she will go through the deed of sale, check out the deposit, the guarantees, make sure that all the terms and the timelines are met. Then they will check who approved the bond. In one situation, it's a cash transaction. Ask for that money to be paid into the attorney's trust account and invest that money for the purchaser with a benefit of interest to the buyer. If the money comes from portions from the government subsidies FLISP, you also follow up with a government institution, the NHFC or Department of Home Affairs, that actually issues this guarantee, and make sure that you also call on that money, that by the time when you register, that the money is actually available. Last week I had an attorney that registered without getting the money in place, 2 weeks actually ago, and it's 2 weeks later now, and they haven't received the money from the NHFC because they never informed the NHFC, and they thought they can just press a button, the money is available. So the conveyancing attorney is a highly skilled person that needs to understand the complexities of arranging the financial affairs in such a way that there's no hiccup. You can imagine if transfer gets through, registered on another person's name, and the money is not available. Now everybody's going to start looking around. The seller passed with ownership, the buyer is the new owner, but you haven't paid for it in full. So that is your third or your second type of attorney that gets involved, the transferring attorney and the bond attorney. And then there's another attorney which really doesn't play a role for the seller or the buyer, because it happens between the attorneys, and that's if the seller had a bond that needs to be cancelled, the bank will instruct a third party attorney, sometimes it can be one of the other attorneys as well, and say to them, I am instructing you to attend to the cancellation of a bond. You must please get a guarantee from the transferring attorney that will again request it from a bond attorney, because the transferring attorney actually controls the entire transactions from a management point of view. So in between, they will exchange guarantees, make sure that the balance is paid in cash, and then the transferring attorney's got another big job, and that is the biggest delays in property transactions, and that is going to the municipality and get a rates clearance certificate. I always find it very strange that we can apply electronically for the rates, and that needs to be paid 3 months in advance. So sellers come to me and say, but hang on, I've already paid my rates and taxes. And we have to explain, you've got to pay it 3 months in advance. And therefore we need all the IDs, the addresses from the buyer and the seller, and also banking details, because if there's a credit, the bank needs to send that, the municipality needs to send the credit back to the seller. So now you apply to municipality, they give you figures electronically, And the crazy thing for me is that once you've paid, you normally get a receipt. And you think, now I can go to the deeds office with that receipt. No. It takes sometimes up to 4 weeks before they process this figure that they gave you that you paid the next day to give you a rates clearance certificate. And we also find in particular, like some municipalities like Cape Town, if I'm selling an apartment with a parking bay and a garage and maybe a garden, or there are also sections, a storeroom, this application for rates clearance goes to 3 different departments. It's supposed to be managed as one package. Then you get a rates clearance from one department, and the other one drags on for 3 weeks, and the one starts to lapse. But again, these are all just like tips what I explained to you that can go wrong or can delay property transactions. So now the transferring attorney has applied for the rate clearance, paid the rates, and now playing the waiting game to get the information back. The next one will be to go to the receiver of revenue called SARS, and either there will be transfer duty payable or will be VAT payable. When it's a VAT transaction, it can be a zero-rated VAT transaction. That's quite easy to get an exemption from SARS, or you need to submit your documents, and SARS will ask for you for an undertaking that you'll pay the VAT on date of transfer into their account, or they will say that the seller, if they've got a good standing with SARS, can pay that money back to them in course of a 2-month VAT cycle term, which is the normal course of a VAT cycle. If there's transfer duty payable, you will have to submit your documents. SARS will give you assessment of transfer duty. And remember that if you don't pay your transfer duty within 6 months, then there are extra penalties that runs after the 6-month period. So now you'll pay your transfer duty, or you'll get your SARS clearance from VAT, and then you've got those documents ready. In the meantime, the transferring attorney will also now have done a deeds office search, got a copy from the old title or current title deed, and then prepare the transfer documents for the seller and for the buyer to sign. The seller signs a power of attorney, plus also any affidavits to indicate marital status and ID, not insolvent, and also signs a payment authority, because that, or where the money must go to once the transfer has been registered, where must I pay that into your private bank account. And it's very important for attorneys also to validate that account. We recently had one situation where a client switched cell phones, and in between that switch, somebody cloned the telephone number and the email addresses and sent a letter off to the transferring attorney to say, hello, I have changed my banking details, please pay it into an F&B account. And luckily, the attorney phoned the client before payment and the same will apply for clients paying money to attorneys. Somebody can clone that letter and send off fake banking details. So always phone the attorney as well and say, I see that I've got an email from you to pay money into your bank account. Can I just validate and verify your account? Because once the money is paid into a fraudulent account, it's not covered by the Law Society's Fidelity Fund because it never landed in the attorney's trust account. So now you've paid the attorney has drafted the transfer documents for the seller to sign, also sign affidavits and transfer duty declarations for the buyer to sign, set up a meeting to go and sign the documents. In the meantime, the bond attorneys will be instructed by the bank that issued and approved the bond, and they'll also draw documents after they've received the property details from the transferring attorneys, and they will prepare their mortgage documents to sign. It's normally a fixed stack of documents to sign. Some of the banks have gone into electronic signature, which is really great because you get a stack like that of documents to work through, and it's quite intimidating documents because you're signing waivers, you're signing indemnities. It's a lot of documents, and that luckily where the conveyancing attorney needs to sit with a client and explain to them all the ins and outs of that. And the main thing is that you've got to sign a debit order as well, and that debit order dictates which time of the month the debit will run off your bond account. Something to remember is that if your bond is registered on the 7th or the 10th and you indicate it on the 1st, just keep extra money in your bond account in case the bond goes off, and never think that, don't worry, it's not going to go off. Make sure you don't want to skip your first payment once the bond is registered and the debit order goes off. So now we've looked at the transferring attorney drafts the power of attorney, the seller's documents, apply for rates, apply for the SARS documents, and if there's a body corporate or a homeowner association involved, then you'll also write a letter to the body corporate or the HOA and inform them that the property has been sold. And usually there's a condition in a particular sectional title act that you can't transfer property unless provision has been made for the payment of the levies to the body corporate. The conveyancer provides a certificate once that arrangement has been made or been paid, and then you are able to lodge the deeds in the deeds office. Remember that I said there are three types of attorneys involved: the transferring attorney, the bond cancellation, and the new bond registration. So the transferring attorney will phone all the attorneys and say, tomorrow we are going to the deeds office. Please give me your documents before we go to the deeds office. They all meet outside or in a particular room, and you get the deeds of everybody. And the transferring attorney then links up all three transactions by writing on the outside cover that this transaction, that one, and that one are linked with each other. They put them together, put them in a box at the deeds office, and then the deeds office will go to the sorting room. In the sorting room, the deeds office will then pair all the documents together, and they will go and pull the information that is on the deeds office system to check, are there any interdicts against the property? Maybe somebody brought an interdict against you selling the property. They also check that you haven't been sequestrated. They also check that the property details are correct, and they print out all that document and put it in the folder. That goes through a scanning process with a barcode, and that gets put on a trolley bin and goes to the sorting room. The sorting room will then go out and dish it out to the junior examiners. The junior examiners normally got a day or two to go through all the documents, make sure that all the documents are there. It's now the power of attorney, the new deed, the rates clearance, the trans duty clearance, the levy clearance, and also your old title deed and any supporting documents that go with that. Once they've gone through that, they send it back to the sorting room, and that takes another 3-4 days. They scan everything. Luckily, we can track every transaction in the deeds office through the scanning, and then it goes to the senior examiner. They also make some notes on the inside of your file if they do find that there are typing errors or documents missing. And if there's a huge document missing or error, they'll put a big R on it. Now that you don't want to see in your life, because it's the R means rejected, and you never want to see a rejected. So because then you get embarrassed, you've got to phone your clients and say, oh, I made a mistake and I've got to do something again. And there are errors that come through. It's human, but sometimes documents are not there that's supposed to be there, or these officer makes a note and say, I'm not sure about what you're trying to do here. Can you come and explain to me? Sometimes you find that they just reject the deeds rather than asking the question. Then the deeds come through to the final examiner on level 3, and then they normally, after 10-14 days, they appear in the preparation room, what we call short the prep room. When it appears in the prep room, everybody, your clerk at the deeds office, will pick up the deeds and phone the office and say, hey, the transfer of Nigel to Meyer just came up for registration today, and there's a bond to be cancelled. So we phone the bond attorneys, we phone the cancellation attorneys and say, okay, are we all ready that we can hand in for registration the next day or the next day? We have 5 days there in the preparation room, the prep room, to organize the finances. Sometimes the seller, the buyer must pay you a little bit of fees. You need to collect a shortfall on the purchase price. In between that time, the estate agent normally has also arranged electrical and beetle and other compliance certificates, and that's also sent to all the parties. So sometimes there's a hiccup with one of the compliance certificates are not issued, and then you've got 5 days to sort out those small items, sometimes big items. And once everybody is ready, and the secretary in the office and the conveyancing attorney then prepares the final finances, you prepare one for your file to see that the money that came in and the money that's paid out will balance. Very important. The second one is what money gets paid to the seller, because on date of transfer, that conveyancing attorney will pay the money over to the seller, less what has been paid to the bond, less what is paid to the agent. So the attorney will do all those payments and facilitate all those payments. And very important that they have the banking details of the estate agent, and also the FFC license of the estate agent, and also then the seller's banking details. And by that time, the bond of the purchaser will kick in. That money will be paid through by guarantee into the bank account of a transferring attorney. So they will collect all the money, do all the reconciliations, and then they will pay out to everybody who needs to be paid out, and do a final reconciliation of finances and present that to the seller and the buyer, and also for your file, because it's critical that your file ends up in a 0. That is once you've taken your fees. So that's very much in a nutshell the conveyancing process. Now the deeds office goes out and the conveyancing attorney appears in the morning between 9:30 to 10 o'clock, appears at the deeds office in front of that's now one step I skipped, but you appear in front of the deeds office to a register of deeds to sign the deeds, which we call the execution of the deeds. And once you execute the deeds, then it means actually it's not like you're cutting off somebody's head like execution, but the deeds office, the register of deeds also signs the deeds. They also put that on their tracking system, and then they after that they keep the title deeds for about a month or 2 or 3, sometimes depend on the um, turnaround times, and then they capture all that information on their system. That electronically you are now also indicated that you are the new owner, and the old owner is no longer the owner. So that takes about that data capturing take a few weeks, and then the title deeds are returned to the conveyancing attorney. If a buyer was a cash buyer, you'll call the buyer and say, "Here, congratulations, here's your title deed, and you must now please put your title deed in a safe place." The reason for a safe place is that in the old days, you could just ask the deeds office for a replacement copy if your title deed is lost, and they'll issue a title deed. Then they became kind of fed up with people are losing their title deeds, and now they say you've got to advertise in the government gazette and the local newspaper, and that takes about that's about a 3-week period, so you lose time. Plus, it costs you about R4,500 in advertising costs. So please, if you have a title deed, put it in a safe place. If you have a bond over the property, the attorneys will send you a copy of the title deed, and they'll send the original to the bank, because the bank keeps that in safe custody as the security until you have paid up the bond. So again, what flows from this, again, your will. Whenever you have bought a property, go and review your title deed. Go and review your insurance, because you've got an asset now. If you have a mortgage, make sure that you have insurance that can settle the debt on your date of death, because you don't want to leave that debt to your family. They may have to sell the property if you haven't got insurance to cover it. Sometimes we find that a husband and wife are married, the husband is economically active, the wife is stay-at-home mum, and now the husband dies, and the wife has got to sell the house because they didn't take out insurance to cover the debt. If you've got a cash, if you bought cash, then obviously you've got cash on when you don't have a mortgage to repay, but keep that title deed in a safe place. And then again, look at your will to redraft. We also provide that service for all EDPF members. We give them free service for a new will. So please make contact with us that we can actually also assist you with a free will. And that's me, a wrap up on the conveyancing process. I think I've most likely covered quite a lot in that few minutes.
Oh, wow. Listen, Meyer, I've been involved in the property sector for 20 odd years now already. And until today, I actually didn't know all of that stuff you just spoke about. I normally just left that to our attorneys to do. And I mean, literally in the years I've been involved with corporates and so on, have done literally billions of rands worth of transfers for corporates. And I've never actually been involved in the process. So you've actually taught me quite a few things today, which is fantastic. They say you're never too old to learn, eh?
Absolutely. And you know what? I've been involved in conveyancing now when we were still typing out on typewriters. We would, in those days when I arrived in Cape Town, every title deed had to be in duplicate. And you couldn't make those days they didn't allow photocopies. They didn't, so you had to retype every deed in duplicate, and you couldn't have a spelling error in one of them. You couldn't also typix information out, because that would lead people to change documents. Every document had to be typed twice without a memory of so the conveyancing secretaries those days were super typists, and you had to check every night every title deed condition. But one would say that conveyancing has become easier with software and technology. It actually has taken it. There's such a lot of extra work that you've got to do, and I always kind of feel like disgruntled when people come to me to ask for a discount on my fees, because we have such a lot of extra burden on clearing the people for FICA, preparing the documents that it goes off in the right manner to all the software programs. Yes, software prepares your documents, but even myself, 20 years ago, I wrote my own software to prepare conveyancing documents. So when we just had to adopt with all these systems, and you pay for this software as well. But if you do a mortgage bond, the banks are moving so much of their admin onto attorneys and responsibilities as well. And they just like give you a stack of documents, and then you've got to carry around, and then you've got to adhere to turnaround times. If you don't do it within a day, they penalize you, and tomorrow, because of a penalty against you, you lose work. If you go to the bank, they say to you, our turnaround time is 6 days. Now you say, hang on, you want me to respond on the same day, but your turnaround. So again, there are so many things that could be better and could be faster. And as we see that the amount of admin work, even with computers, are just getting more and more. And now you've got Fika, you've got FIC, you've got Popeye. It's like crazy on doing with all these regulatory aspects, which really, as I say, people don't understand what is involved in them. They think, oh, you just complete a couple of forms, you type on the typewriter, and it pops out the documents. It's a complex, and then you get problems with where people start to fight with each other about small stuff. I love the work. It's really enjoyable, and for me, it's enjoying to see people helping people to own and to sell a property, because it's positive energy that flows out every day.
Wow, that's fantastic. And listen, I applaud you for the patience that you show. I mean, I see it every day. Attorneys have to have extreme patience with clients who literally know nothing about the process, don't understand legal documentation, don't understand the implications of the legal documents that they sign. And often, I see it more often than not, where a document gets stuck in front of somebody's face and they just sign without even thinking. So I applaud you, and I thank you for the service that you render to us as EDPF and our students, as well as the public at large. But for now, Meyer, thank you very much for your time. It's always a pleasure having a conversation with you, because literally every time I talk to you, I learn something new, and I know that our students and the public out there with this 50-day challenge has learned quite a lot about the transfer process, what goes into it, and all the legal documentation and the processes. It is absolutely amazing how you guys cope on a daily basis with this. So thank you, Meyer, for your time. Thank you for the public out there that listen to us diligently every day on this 50-day challenge. We are nearing the end of the challenge now, hence the reason why we thought we'd talk about the transfer process, because it is something that you have to understand. You have to know when you do a property purchase or even a property sale, that you have to know these things and understand what goes into it, so that you don't get frustrated when it takes 3 or 4 weeks longer than you thought it would. But thank you, Meyer. Thank you, Private Property, for allowing us this platform for the EDPF Property Academy to run this 50-day challenge. And thank you to you, the audience, for diligently watching us. We'll see you again tomorrow. For now, goodbye. Have a great day. Thanks, Meyer. Thanks, Private Property.
Thanks a lot, Nigel. Keep well.